Challenges for attorneys. Attorneys do recognize the digital inheritance gap, but technology changes fast. Let's review the common approaches they take and the problems with each. 1. Password memoranda, the most common. They tell clients to create a separate paper document. It is not part of the will on purpose because a will becomes part of probate and may become public record. Instead, the will says something like, "My executor should refer to my memorandum of digital assets." The problem is that this document quickly becomes dated. Passwords change. 2FA gets enabled or changed. Accounts get added. The paper gets lost. The spouse cannot find it. And worse, if someone finds it while the person is alive, it's a complete security breach. Attorneys know it's insecure, but it's still the most practical option they have. 2. Power of attorney provisions. Lawyers now frequently add special digital language into financial power of attorney documents. These attempt to give an agent authority to access online accounts if the person becomes incapacitated. This comes from a legal development called the Revised Uniform Fiduciary Access to Digital Assets Act. It allows an executor or agent to request access from companies like Google, Apple, or Facebook. The problem is that this grants legal permission, not technical access. The executor must still contact the company, send death certificates, wait weeks or months, sometimes get denied. And companies often only provide a data download or account deletion, not actual login access. So the authority exists, but the functionality still doesn't. 3. Company-provided legacy tools. Some attorneys now instruct clients to set up built-in legacy systems. Google Inactive Account Manager, Apple Legacy Contact, Facebook Memorialization. These are actually useful, and lawyers increasingly recommend them. The problem is, they are platform-specific. They cover only one company and do not handle banks, crypto wallets, and most other situations. A person might have 120 accounts. These systems may cover 3 to 5 of them. 4. Physical storage. Some attorneys advise clients to put USB drives, password lists, or instructions into a safe deposit box or home safe. Executors generally cannot legally open a safe deposit box immediately after death, unless that person already has access to the box or safe, which can be risky. Banks want probate docs, court orders, or multiple witnesses. In either case, the data usually becomes dated as it is a chore to maintain. 5. Password managers. Some attorneys recommend using a password manager and sharing the master password with a spouse or child. This sounds logical, but while alive creates a serious security exposure. After death, the family may still be locked out due to two-factor authentication or biometric locks. It also only addresses part of the problem. 6. Business and crypto instructions. This is where attorneys are the most uncomfortable. For crypto wallets, private keys, online business accounts, etc., attorneys can often only document that the client possesses digital currency assets, but they cannot actually manage those assets. If the keys are not recoverable, then the assets are permanently unrecoverable. The reason attorneys struggle is not a competence issue, but rather a structural mismatch. Estate law answers, who should receive the asset? Technology asks, what are the credentials? Those are two completely different systems. Attorneys can transfer legal rights, but digital systems require credentials, devices, or cryptographic keys. That gap is the entire digital estate problem. This is why we built SafeInity.com, It allows you to manage all types of digital information, including secure access to your password manager in one secure and central location. Easily pass on that tangled mess of accounts, passwords, phone access, and two-factor authentication that define our modern lives. Upload files, create ultra-secure documents, set up beneficiaries, and connect files to beneficiaries. Set up a simple account, or take advantage of some seriously advanced security designed for high-value accounts. The app has a heartbeat function, so that when you stop responding, access is automatically and securely granted to beneficiaries, executors, and others. Make life easier for your loved ones. SafeInity.com